In Pennsylvania, officers of the Fish and Boat Commission have the power to trespass on any land or water without a warrant. For one couple, that led to repeated harassment at their lakeside home. But the Constitution's Fourth Amendment protects all Americans, including Pennsylvanians who live near water. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice. Together with co-host Keith Neely, today we're talking with IJ attorneys Kirby Thomas West and Dylan Moore about a new case challenging warrantless trespassing. This is Beyond the Brief. So Kirby, can you tell us about this case and how IJ ended up challenging the warrantless surveillance?
Sure. So our client in this case, Tim Thomas, had heard about IJ's work. When what I'm about to tell you happened to him, he started kind of Googling frantically, who can help me with an issue with a Fourth Amendment violation? And of course, given our work and our project on the Fourth Amendment, IJ was one of the top search results, and he reached out to us. But what led Tim to do that Google search to get connected to IJ is two separate pretty egregious Fourth Amendment violations on his property by Waterways Conservation Officers. Now, these are officers that work for the Pennsylvania Fish and Boat Commission, as we call them colloquially here at IJ, the fish cops. So it's a funny name that we use, but these are the officers that are charged under Pennsylvania law with enforcing fishing regulations and boating regulations. But they are real life police officers, right? They carry guns. They are authorized to arrest people for violations of the fishing laws and boating laws. So one of these officers, Ty Moon, on two separate occasions conducted pretty invasive warrantless searches in Tim and his late wife Stephanie's property, searching in his yard, around his house, up on his porch, banging on his door, and all of this without a warrant. And the reason that they're empowered to do this is a Pennsylvania law, which I have a feeling you guys are going to ask us about. But he, after having this officer harass Tim and Stephanie in this way, he felt like he really needed to do something and reached out to IJ to see what he could do.
So we'll talk about the specific statute in Pennsylvania in a second, but these fish cops, as you call them, is that unique to Pennsylvania or does that exist elsewhere?
So other states also have fish and boat commissions. They also have, it's a similar category to game wardens. I think in some state they may actually be within the same agencies. But essentially, every state does have conservation laws to protect the natural resources, be that game or fishing, and also to keep waterways safe. And of course, that's totally valid, right? We want to have safe waterways. We want safe boating, and it's important to conserve natural resources. But the officers who are in charge of enforcing those laws should be held to the same standard as any other kind of officer. And that means if they want to conduct a search, they should get a warrant.
Well, talking specifically about the searches that happened in Tim's case, first, what did they suspect him of? And then second, tell us a little bit more about how invasive some of these searches were.
Sure. So in the first instance, Officer Moon thought for some reason that's kind of unclear to us that Tim had been fishing without a license. So that was the alleged violation of the fishing laws. There's nothing urgent about that, right? If he thinks that Tim had been fishing without a license, he's not actively fishing without a license when Officer Moon got to his property to conduct the search. There was no kind of, emergency situation where he needed to do this search right now. Of course, he could have gone and got a warrant if he thought that there was some evidence of Tim fishing without a license, but he didn't do so. Instead, he went to Tim and Stephanie's house. Stephanie was home alone at the time and battling stage 4 cancer. She was, largely immobile due to the cancer treatments at that time. And so when she heard someone knocking on the door pretty aggressively, she was nervous. Tim wasn't home and she felt vulnerable in that condition. And so she didn't answer the door. What Officer Moon should have done at that point is left and come back another time or gotten a warrant, better yet. Instead, he walked through the Thomases' yard, around to the porch in the back of their house, and continued to pound on the door, yelling, "I know you're in there, open up."
Oh my
And
gosh.
just further, terrifying Stephanie, who's in this very vulnerable condition. When Stephanie again didn't answer the door, he started taking pictures of the porch. He went down to their dock, which is just a few yards away from their house. He took pictures of the fishing equipment and the boat and their yard. And all of this for an alleged violation of fishing without a license, just this very minor kind of, ticky-tack alleged violation, which, there's no evidence that Tim has done. And indeed, he had not been fishing without a license. But that's the first incident. The second incident, the same officer was camped out across the lake from Tim and Stephanie's cabin. Now, I say a lake, and some of you might be picturing like, Lake Michigan or Lake Erie or something. This is a very, very small lake. It's a beautiful, tiny lake in northern Pennsylvania. There's no, kind of motorboats. There, no speedboats. Rather, there are some motorized boats, but it's very, very small, very peaceful. So the officer came and was staked out across the lake from Tim and Stephanie's cabin, and he was watching Tim, who was fishing on the lake, through binoculars. And he says that he saw Tim fishing with more than 3 rods, that you're allowed to fish with. He said he saw him fishing with 8 rods, and under Pennsylvania law, you can have 3 rods on your boat, or not on your boat. You can be fishing actively with 3 rods at a time, and you can also be using depth placement devices, which Tim was doing. So he had 3 rods that he was using for fishing, 3 depth placement devices. But the officer alleges that he saw Tim actually fishing with 8 rods, and because he had been fishing with too many rods, the officer came back to Tim and Stephanie's house again, marched right past no trespassing signs through the yard, this time just feet away from an open window where Stephanie was taking a bath. And it might sound odd if you live in a very populated area, but this is a rural area that's covered by bushes and, out of sight away from the yard. It's a beautiful clawfoot tub, and Stephanie was just, in her bathroom and in this kind of very private environment. And the officer walked right by the window, marched down through the yard to the boat to seize all of Tim's rods and confront him about this alleged violation. Again, searching and walking onto the property without a warrant, even after Tim told him not to and to please leave.
Was Tim ever charged with anything? Was he ever charged with any sort of like illegal having extra rods or whatever this, nuanced thing is? Or did the officer just sort of commit these Fourth Amendment violations and then leave everybody alone?
So Tim was charged with something on both occasions, and neither charge ended up sticking. So the first time, Tim received a citation in the mail a little bit after the unconstitutional search, and he essentially called the WCO's boss and explained what happened, lodged a complaint, and the WCO just dropped that charge before it went to court. And then after the second unconstitutional search, Tim was charged and actually went to court for fishing with too many rods against Pennsylvania law. And at the trial court, he was found guilty. He represented himself, but on appeal, that conviction was overturned.
So we keep kind of talking around this statute that lets these officials do this, the going onto the property and whatever. What exactly does that statute say, and what about it is unusual?
So the Pennsylvania law that governs basically the authority of Waterways Conservation Officers says that they may enter onto any land or water in order to enforce essentially Pennsylvania's fishing regulations. Now, that's it. Full stop. They can go anywhere.
Wow.
It doesn't say enter on any land or water with a warrant or,
and permission
right,
or whatever.
with consent. It just says you may enter onto any land or water, full stop. This is absurdly unconstitutional, I would say, right? This is almost exactly what the Fourth Amendment was designed to prevent, which is something called general warrants. So general warrants are something that at the time of the founding, the founders, thought was important to guard against in order to preserve property rights. And it's this idea that you can have essentially a warrant to say, go figure out crime. officer, go look and see if you can dig something up. You don't have to say what specific crime you think has happened. You don't really have to say where you think it occurred, who did it. You can just kind of poke around and look and say, look in this general area and see if there's been some bad stuff happening. General warrants are, just as I said, just kind of plainly unconstitutional, but this Pennsylvania statute effectively operates as a general warrant, right? It says that WCOs can go on any land or water. And even...
in a way, it goes further than a general warrant, right? This says they can go on any land or water performing their duties. So he can go on to Tim's land to check on his neighbor if he wanted to, right? That's kind of nuts, isn't it?
That's exactly right. Yes, it is. It's broader than a general warrant. And this is different even than, as kind of loyal listeners might know, the other Pennsylvania statute that IJ is challenging in our open fields case. In the open fields case, we're challenging the acts of game wardens who are conducting searches on private property. But the game wardens, again, this is also very problematic, but the statute says that they can go basically on any land except curtilage. And so the curtilage, in kind of, Fourth Amendment speak, is the yard. It's the area that's immediately around the house, and Fourth Amendment doctrine is very clear that curtilage is entitled to special protection under the Fourth Amendment, and that officers just can't walk into your yard willy-nilly, right? This is part of your home, part of the area that you live in, and has special protection. But the law that governs the Fish Commission officers, the WCOs, does not exempt curtilage. It just says any land or water. So it's extremely broad.
So a regular cop wouldn't be able to do what these fish cops can do, right? But what a regular, officer of any kind can do is still pretty broad, right? Because you can have land that extends pretty far beyond what's kind of the immediate yard around your house, and that area is kind of still unprotected. So what do we want a court to say about this statute? Like, if they just added and, accept curtilage to the statute, like, that doesn't solve the problem, I don't think.
Right. I think that's a really good point. And I think that if they had added something like that, this would be more akin to our open fields cases, right? In which we're saying, if you have more property than just your home and a small yard around it, that doesn't mean that you lose the protection of the Fourth Amendment, right? So in this case, we're saying that just because you live near water doesn't mean that you lose the protection of the Fourth Amendment. But both things are true. Of course, if you have broader property beyond just the immediate curtilage of your home, that should still be protected under the Fourth Amendment. And similarly, just because you live near water, you're not giving up your Fourth Amendment rights, and no officer, be it, as you mentioned, Kim, a normal police officer wouldn't be able to do this. But even so, a Waterways Conservation Officer is still a law enforcement officer. They still have the power to arrest you. They carry a gun. They can, charge you with something that will ultimately put you in jail. So the Fourth Amendment extends to them too, and you shouldn't lose your Fourth Amendment rights just because you happen to live on a lake.
And to tell you the truth, the federal law on all of this is generally pretty bad. Federal courts aren't too interested in protecting the open fields of people's private property. But even under the more forgiving federal standards to law enforcement officers, you can't go into the curtilage. So this is just an extremely clear-cut case. And if the federal Fourth Amendment protections on people coming into your house, into your property without a warrant mean anything, they mean that intrusions like this one are just plainly off the table.
Well, and mentioning federal law raises up another distinction between this and our other Pennsylvania case. In the Pennsylvania game warden case, we brought a state constitutional claim in state court. Here, we're bringing a federal constitutional claim in federal court. What was the rationale behind that? Was there a strategic advantage to doing that? How did you guys decide to make this a federal Fourth Amendment challenge and not more of a state challenge that we see in some of our other cases?
Well, in our state cases, what we're trying to do is get state courts to say our Fourth Amendment analog, the part of our Constitution that looks a lot like the federal Fourth Amendment, goes further and protects more land. And so that's what we're trying to do with our Pennsylvania case against the game wardens. But here, while we're trying to expand, state courts' understanding of these rights, we're also trying to make sure that the federal rights aren't being eroded sort of sneakily. And like I said, we want to make federal courts take the Fourth Amendment more seriously and eventually walk back this open fields doctrine. And to do that, we have to start somewhere. And I think that this case is a very good place to to begin those efforts to ultimately getting the federal courts to take this as seriously as some state courts have.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So you both have been sort of talking about how obviously unconstitutional this statute is. And, it's not new. It got passed, however long ago. And so how did it get passed in the first place? And how has it never been, struck down until now?
So I don't know exactly when the statute was passed, but you're certainly right. It's been around for a long time, right? Like, this is something that WCOs have been able to do in Pennsylvania for a long time. I actually know this firsthand because I grew up on a small lake in northeisteastern Pennsylvania. So
this is just a personal vendetta of Kirby's.
I don't know if I would say that.
We know why we fought this case now, yeah.
But I think that it's a very good question. I think one of the reasons that statutes like this exist, or that this statute exists in Pennsylvania, is in part people don't know so much what the Waterways Conservation Officers are up to unless they do live on a lake. Like, right, most of the population does not live immediately near a body of water, though enough do that this is an area of, pretty huge concern. But I think also when you talk to these officers, the way that they talk about it is just, well, of course we need to do this, right? Like, of course we need to do this. How could we possibly, one of the things that one of the officers said to Tim was, all these houses on lakes and stuff are so close together. How could we do our job if we couldn't walk onto people's yard? Like, we just need to be able to do this. And I think it comes from this instinct of sort of deferring to law enforcement when they say that they have some kind of necessity. Without maybe taking that extra step of thinking like, okay, you allege that you need this authority, but can you have this authority under the Constitution? And I think we see this a lot, right? Where in other contexts as well, where too often people are not taking that next step and they just immediately defer to law enforcement when they say this is something they need to do. And in the case of Waterways Conservation Officers, I also just don't think that that is a particularly compelling response because they're the Fish and Boat Commission. Ideally, they would be in their boats on the water.
That would make sense.
And the place, as you might imagine, that fishing violations are happening is generally on or near the water. So they can do a lot from their patrolling in their boats on the bodies of water, which they're totally entitled to do. They don't need to go skulking through people's yards in order to do their jobs.
Well, and of course, if they need to, they can get a warrant, just like any police officer could. So, I mean, it's not as though the Fourth Amendment says you can never go on this person's property. You just have to have a warrant by an independent judge. And Kim's question earlier about how obviously unconstitutional this is kind of raised another question in the back of my mind, and maybe I'm thinking about this too much from a qualified immunity standpoint, because I know that this case is about prospective injunctive relief. We're just trying to get a court order saying you got to stop doing this. But why wasn't there a discussion, and maybe there was a discussion, about suing Ty Moon individually? Because it sounds to me like this is obviously a Fourth Amendment violation. If that right isn't clearly established, I'm not sure what is. Was there a discussion about that? And if not, why focusing only here on injunctive relief?
I think a big part in this case is rather than punishing the individual officer for violating the Constitution, which he did, we want more structural change about the types of laws that states can put into practice when they're trying to do things like conserve wildlife. So here, the most important thing is just making sure that people have a right to be secure in their homes and the immediate areas surrounding their homes, and that states can't infringe on that. So changing the law rather than holding any individual officer personally responsible, I think is the animating factor behind this case. And just ensuring that like these officers who are technically following the law of their state are following laws that follow the Constitution. I mean,
yeah, I mean, for one, it seems noteworthy that, our case revolves around this Officer Moon, but presumably if the statute allows this, every other officer is doing this because the statute kind of instructs them to do it, not just, gives the permission to it, but kind of, tells them to.
Almost commands them.
Right.
Yeah.
And And so to me, the idea that like, oh, somebody's doing an unconstitutional thing because the law lets them do an unconstitutional thing, like I have a bit of a like ick reaction to that. But, coming after him as an individual kind of unfairly singles him out, I would think, in some ways.
Sure. And while officers definitely have a responsibility to make sure that everything that they do complies with the Constitution.
Sure.
Here, the most important thing is just making sure that the laws that give them the power under the state statutes also comply with that Constitution.
Right. So IJ has had cases that involve the Fourth Amendment, and in the context of game wardens and taxidermists and now fish cops. Is it a coincidence that all of this is sort of existing in some sort of hunting, fishing, outdoorsy kind of space, or is there some sort of particular Fourth Amendment connection there, or like is that kind of the whole realm where our Fourth Amendment stuff is focused?
It's definitely not the whole realm. I think that it is an area where these kind of things tend to pop up for some of the reasons that you've already talked about, and Keith, that you've talked about, which is that the open fields doctrine kind of empowers officers to walk onto pieces of property that are sort of beyond the curtilage, beyond the immediate yard around one's house. And I think one of the most common violations that you might be looking for in like a large wooded area on someone's property or, kind of open fields are hunting violations. And as I mentioned earlier, I think similarly with the Fish Commission officers, the WCOs, they feel like, they need to be able to do this because, fish don't stay put. They go from one body of water to another and they're moving around. So we got to be able to move around.
We got to go onto that guy's porch because the fish went onto his porch.
And I say that, a little tongue in cheek, but I think genuinely, these officers view their job as taking care of wildlife, preserving wildlife, and the wildlife is everywhere, right? And so they kind of view their responsibilities as being everywhere. And I don't think that maybe the state or the government has internalized quite enough that, as Kim, as you've mentioned a few times, like these are still law enforcement officers, even though their job is a little bit different than like solving what we think of as sort of normal like property crimes or violent crimes or something like that.
So we've talked a lot about the open fields doctrine today. How is this case designed to undermine the open fields doctrine? We've talked a little bit about Pennsylvania game wardens. There, the angle is a little straightforward. We're trying to get state constitutions to stand a little higher than the Fourth Amendment right now. What are we trying to do here in federal court to advance our project forward, whether it's with open fields or maybe it's just expanding the Fourth Amendment generally?
I do think this is slightly different than our open fields work, though, as you mentioned, it's related because I think a lot of these same kind of rationales come up when it's game wardens or Waterways Conservation Officers. But I think, as Dylan was saying earlier, the point of this case is more to say a state legislature cannot exempt an entire class of officers from the restrictions of the Fourth Amendment, right? You can't say, okay, you guys, you WCOs, you do not have to follow the Fourth Amendment warrant requirement, unlike all the other officers in our state. And so we want to just make that incredibly clear that states can't, by statute, get around the obligations of the Fourth Amendment. And also, as we were talking about earlier, to make clear that, like, this is a general warrant, right? This is something that doesn't actually come up a lot. But when it does, we should be eager to say, this is a big no-no from the time of the founding to now under the Fourth Amendment.
So what's next in Tim's case? I know that we just filed this. I think it was September 23rd, 24th. So not too long ago. Has the government filed an answer yet? Do you expect them to file a motion to dismiss? I mean, what are the next steps in this case?
Sure. So next up would be either the government's answer or the motion to dismiss. They haven't filed either one yet. And they have about a couple weeks from now to do so. I think we're probably expecting a motion to dismiss in this case because it really is about whether this Pennsylvania statute is legal under the Fourth Amendment. And so I think that is the kind of question that can be settled pretty early on in a lawsuit.
Right.
So I expect that in a couple weeks, the government will move to dismiss the case and we'll be fighting from there.
So real quick, for the non-lawyers among us, what exactly is the difference between the state filing an answer and filing a motion to dismiss? And you said, like, oh, this should be a thing that, gets done faster. Like, why is an MTD the faster route? Like, what do these things mean?
Sure. So Apologies to the non-lawyers first
It's
off.
really just me. All the rest of y'all know what's going on.
Normally, for our cases, after the government gets our complaint, which is a long document normally that has a bunch of numbered allegations of what happened and why we think that it's wrong, they have two options. One is to answer the complaint, and they'll pretty much either say admitted or denied for every claim that we make. And from there, the parties move into a phase called discovery, where they exchange a lot of information to try and figure out exactly what the facts were before the court or a jury settles the question of whether the law was violated. The second option for the government is to file a motion to dismiss. And basically what the government is doing there is saying, even if everything that you say in your complaint is true, we still win under the law. So to do that, the government in this case will basically have to say, sure, Officer Moon did all the things that you said, or at least for right now, we're not going to contest whether he did those things. But even if he did those things, he was allowed to, and there was nothing wrong with that under the Fourth Amendment. And so it'll be a little bit quicker in this case if they file the motion to dismiss, because what we're really after is a court ruling that says that this Pennsylvania statute that grants this wide authority to the fish cops is unconstitutional. And that's probably something that we can settle pretty early on if the government doesn't want to fight about the particular facts of what Officer Moon did.
So would it be fair enough to say that the difference is sort of, this is a question of just what does the law say versus what does the Constitution say? Do those things line up, yes or no, as opposed to, is this specific circumstance playing out in a way that's constitutional or not based on, some nuances of fact and this and that?
Right. I think that's a good way to characterize it. And if they file the motion to dismiss, it'll all be about, are the fish cops in Pennsylvania empowered to do the certain things that the state legislature has said they can do, consistent with the Fourth Amendment? And then we can have that fight sooner rather than later, which would be good.
So what's next for IJ's project on the Fourth Amendment?
Well, we just launched a case out of Norfolk, Virginia, challenging a system called Flock. It's this private company that a lot of cities have hired to basically track cars going all along public roads so that they can see, based on intersection 1, you turned left, and then intersection 2, you turned right. And you do that every day. So that must mean that you're going to the grocery store. And we're alleging that this wide system of surveillance that covers large swaths of lots of cities and counties in the country is unconstitutional under the Fourth Amendment.
So before we wrap up, I want to kind of jump back to our client, Tim. Every IJ client is trying to fight for what's right. What brought Tim into this case? What is he fighting for? How is this more important than just, this one isolated game warden, or I guess in this case, a fish cop who's been making his life a little miserable? What drives him here?
Yeah. Well, I think as you guys all know, and probably viewers know as well, IJ clients are pretty uniformly great. And Tim is no exception. He's not in this case for some kind of, personal vendetta against Ty Moon. He's really in this case because he doesn't want what happened to him to happen to other people. And even more importantly, he doesn't want what happened to Stephanie, his wife, to happen to other people. And, very sadly, Stephanie actually passed away this summer. And we were in touch with Tim the whole time and kind of said, we can delay this case, whatever you need. And Tim just remained energized. He said, I want to do this in Stephanie's honor. I want to, this is a project that I'm doing for Stephanie's memory to ensure that other people don't have to deal with this kind of feeling of fear and vulnerability that Stephanie experienced when Officer Moon was conducting these searches on their property. And Tim is just he's a happy warrior, and he's ready to join us in this fight and stick it out as long as it takes to make sure that we get the right outcome here.
So, wow, that's amazing. Tim really sounds like an incredible guy. But thank you so much, guys, for coming in and talking with us. And for the audience, stay tuned. We'll have a video about the Norfolk case that Dylan mentioned in a couple weeks.
Thank you.
That's it for today. Thanks again for watching, and don't forget to subscribe.